Deloitte and Touche vs. Liver Incorporate, 2017, SCC 63, a judgment in which the Supreme Court of Canada revised the framework of examining a defendant's duty of care in cases of negligent misrepresentation of performance of a service, was published on December 20, 2017. Livent, by its receiver, brought an action for negligence and breach of contract against Deloitte regarding the audit of Livent's financial statements. In August 1997, Deloitte discovered irregularities in Livent's accounting for the reporting of profits. Deloitte continued to aid Livent's business endeavors by preparing Livent's 1997 audit, despite the fact that they misrepresented the basis of the reporting of profit. A new management team was hired to Livent's in 1998 by new equity investors who also identified the fraud and irregularities. Deloitte instantly withdrew its audit opinion, and after an internal review and re-audit, Livent published restated financial statements. The stock price of Livent collapsed as a result of these restatements, and shortly after that it applied for insolvency protection in both Canada and the US. Livent sold its assets in October 1999, and a month later it entered receivership. The special receiver for Livent sued Deloitte in tort and contract for $450 in damage. According to the trial judge, Deloitte owed a duty of care to Livent for the ultimate goods of its shareholders. The auditors were obligated by Deloitte to act in a way that effectively restricted Livent's access to the financial markets and forced it into formal insolvency more than a year before Livent ever applied for insolvency protection under this responsibility. Deloitte claimed that determined effort was made to hide the accounting frauds and irregularities from it. Even if Deloitte had been careless, Livent's losses should not be recoverable because they were driven on by its own illegal actions. The court emphasized a major shift in the required level of care for auditors in the modern day. It was decided that in some situations, additional requirements above what would be considered reasonably competent and cautious accountant generally may be necessary. The standard of care demand of auditors, particularly in complicated or high-risk audits, has undoubtedly increased as a result of this case. Additionally, it reaffirmed the limited grounds for an auditor to use internal frauds as a defense against a claim of professional negligence. The trial judge came to the conclusion that Deloitte did not uphold this standard of care when it approved Livent's 1997 financial statements and failed to report the irregularities in August 1997. As a result, Livent received just under $85 million in damages from the trial judge.
AZIQ vs. Grant Thornton, in which 21 million in damage were awarded against GT UK in favour of AZIQ. AZIQ claimed damage for breach of contract or in tort arising out of the negligent performance by GT. The claimant, AZIQ, a fire and emergency services provider, had engaged defendant, Grant Thornton, to audit its financial statements. The senior management team at AZIQ behaved in a fundamentally dishonest way. GT accepted that it was negligent in several respects as the company auditor in failing to detect those matters. The losses claimed by AZIQ resulted from GT failure to detect fraud and are likely to result in material losses to the company. In this regard, it relies upon the fact that GT failed to exercise appropriate professional skepticism in its conduct. GT argued that they had a claim against AZIQ for fraud, for falsely representing to GT that all audit information had been made available to them during the audits. The AZIQ case does serve to highlight the nature and scope of responsibility the auditor accepts when performing statutory audits and providing unqualified audit opinions. The ongoing costs resulting from such mistakes can be substantial and significant. The judge did find that AZZUDDIN was liable for negligence in some of the losses suffered, including dishonesty of the part of AZZUDDIN senior management and a failure to look after its own interests. GT was found to have acted dishonestly by the judge.